Into the courtroom, please. Hagerman Schofield, did the family members get here yet?
Miss Marion, his mother's here, and she's going to be the state's first witness.
Yes, sir.
We have her outside, Your Honor.
Yes, sir.
We should approach real quick, just to give Your Honor sort of a...
Yes, sir. For the record, it's State of Tennessee versus Billy Turner. Docket number 1705881. Mr. Turner is present. Mr. John Keith Perry, Mr. Andre Thomas are present for Mr. Turner. Mr. Paul Hagerman and Mr. Austin Schofield are present for the state. Are both sides ready to proceed?
Yes, ready.
Do you have all 6 deputies in the courtroom right now? Deputy Smith.
Yes, sir. Deputy House, she's outside.
Tell him not to stray. Deputy Smith.
Stay close.
Let me bring in the jury, please, sir.
Yes, sir.
Okay. Ladies and gentlemen of the jury, good morning.
Good morning.
Everyone can have a seat. How's everyone doing? Okay, here's your first test for the day. What's the last thing I told you yesterday? Bingo, somebody got an A. Now, did anyone watch, hear, listen, read anything about this case overnight that the media did cover?
No.
Thank y'all, because I've promised, I've had people, I've told that before, and they come back the next day and say, just coffee, I couldn't help myself, and I did it anyway. If you can all stand, please raise your right hand. I need to administer a different oath before we can get started this morning. Do you solemnly swear or affirm that you will well and truly try the issues of traverse joined herein between the state of Tennessee and the defendant Billy Turner, a true deliverance make and a true verdict render according to the law and the evidence, so help you God?
I do.
Thank you, ladies and gentlemen. You may be seated. Ladies and gentlemen, you're taking an oath that you will render a true verdict on this case based only on the law and the evidence. I've introduced some of the deputies to you that will be with you through the course of this week. And Deputy Smith is standing to my right. Deputy Barnes is seated to my left. Deputy Phillips is standing to my left. And at the back of the courtroom, Deputy Hollister, Deputy Chambers, and Deputy Yancey. These are the 6 deputies that will be with you throughout the course of this trial. You can talk to them, but you can't talk to them about the case, and they cannot talk to you about the case also. All the deputies, raise your right hand and be sworn, please. Do you solemnly swear or affirm that you would take charge of this jury, that you would keep them separate and apart from all other persons, and not allow anyone to communicate with this jury, and as it concerns the case on trial, you would not communicate with the jury, allow the jury to communicate with you, and that you will deliver this jury safely into court, so help you God?
I will.
Thank you all. Ladies and gentlemen, the deputy has taken an oath that they will, in fact, not allow you to talk to anyone, not to communicate with anyone, and they will bring you to court, and again, cannot talk to you about this case at all. You have in your possession jury notebooks that I told you to get yesterday. And included in those jury notebooks are some preliminary jury instructions. There are about 9 pages of preliminary instructions. I am required to present this to you and to read it to you. I wish I could tell you, just read it with you when you get back to the jury room and tell you to read it yourself, but I'm required to read this to you. I give you a copy of these instructions. You also have a copy of the final juror's instructions also. Those are your personal copies. You can write, highlight, underline anything on those instructions that you choose to do so. I'll give you a copy because I think most studies have indicated that if you have something to read, rather than have somebody to read at you, that you will probably retain more information. Do not feel obligated to read this information. I'm, in fact, obligated to read it to you. This is State of Tennessee versus Billy Turner, indictment number 1705881 in the criminal court for Shelby County Division 7. And these are your preliminary jury instructions. Before we begin the trial, I want to outline how the trial will be conducted and what functions the jurors, attorneys, and I will perform during the course of the proceedings. At the end of the testimony, I will give you more detailed instructions on how you are to reach a verdict. The state of Tennessee has charged the defendant with the offenses of first-degree murder, conspiracy to commit first-degree murder, and criminal attempt first-degree murder. The document contained in the charge is referred to as an indictment. An indictment is a formal written accusation charging the defendant with a crime and is not evidence of anything. You shall not have any sympathy or prejudice for or against the defendant or for or against the state of Tennessee, or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think truth dictates and justice demands. The essential elements of first-degree murder in count 1 of the indictment are as follows. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed Lorenzen Wright. And 2, that the defendant acted intentionally. A person acts intentionally when it is a person's conscious, objective, or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. The essential elements of conspiracy to commit first-degree murder in count 2 of the indictment are as follows. 1, that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained. And 2, that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder. And 3, that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder. And 4, that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of the conspiracy. The essential elements of criminal attempt first-degree murder in count 3 of the indictment are as follows. 1, that the defendant or one for whom the defendant is criminally responsible intended to commit first-degree murder of Lorenzen Wright. And 2, that the defendant or one for whom the defendant is criminally responsible did some act intending to complete a course of action or cause a result that would constitute first-degree murder under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of first-degree murder. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit first-degree murder. The defendant has pled not guilty to the indictment. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the jurors seated in this trial unanimously find that the state of Tennessee has proven essential elements of the indictment beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. Statements of attorneys are not evidence. The only purpose of opening statements is to help you understand what the anticipated evidence will be. The state would outline the evidence it intends to present so that you have an idea what the state will attempt to prove during the trial. After the state's opening statement, the attorney for the defendant may make an opening statement if the attorney elects to do so. Next, the prosecution will present its evidence in the state's case in chief. The evidence in this case will most likely consist of testimony of witnesses, physical exhibits, and documents. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will have an opportunity to submit evidence through witnesses and exhibits. A defendant is not required to offer any evidence or to testify. The state of Tennessee always has the burden to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof The state may then submit what is known as rebuttal proof. After the state's rebuttal, the defense may offer additional proof. After you have heard all of the evidence, I will instruct you about the rules of law that you are to use in returning your verdict. The state and the defense may then submit final arguments. As with opening statements, closing arguments are not evidence. In closing arguments, the attorneys will summarize their positions to assist you in understanding the evidence that was presented. The final part of the trial occurs when I instruct you about the procedures and rules of law that you are to use in returning and recording your verdict. After I read the concluding jury instructions, I will select and excuse randomly the alternate jurors. The final 12 jurors will retire to the jury room and start your deliberations to render a decision in this case. Your deliberations are secret, and you will not be required to explain your verdict to anyone. Having described in outline form the trial itself, let me explain the functions that the jury and I will perform during the trial. I will decide which rules of law apply in this case. My decisions will be reflected in responses to questions and objections that attorneys make during the trial and in my final jury instructions. The jury's job is to determine what the facts are from the evidence. You must then apply the law in the jury instructions to the facts, and from that process, you will arrive at a verdict. State of Tennessee has the burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden remains on the state throughout the entire case. The defendant is presumed to be innocent of the charges against him. Therefore, a defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of witnesses who testify. You must decide whether you believe what each person says and the importance of that person's testimony. In making that decision, it might be helpful to consider the following questions. Did the person impress you as honest? Did the witness have any particular reason not to tell the truth? Did the witness have a personal interest in the outcome of the case? Did the witness seem to have a clear memory of the events testified about? Did the witness have the opportunity and ability to observe accurately the matters testified about? Did the witness appear to understand the questions clearly and answer them directly? Did the testimony of a witness differ from the testimony of other witnesses? These are some of the considerations that will help you determine the credibility of the testimony of each witness. In reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your responsibility is to think about and evaluate the testimony of each witness you heard and decide the facts of this case. You might have heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. You may consider both kinds of evidence, which are considered to be of equal value in the law. You will not receive a transcript of the proceedings at the end of the trial. Therefore, you must listen very carefully to the testimony. You will be allowed to take notes during the trial for your personal use during your deliberations. You are not required to take notes. Independent memory can be as precise as any written notes. You will be provided with notebooks should you decide to take notes. You shall not talk with any of the attorneys, witnesses, or the defendant involved in this case. Please do not talk with them about anything whatsoever. You might see them in the hallway, on an elevator, or at some other location. If you do, the best standing rule is not to say anything to avoid any inferences of impropriety or impartiality. During the trial, you will receive all of the evidence you may properly consider to decide the case. Therefore, you shall not attempt to conduct any private investigations or gather any independent information that you think might be helpful. Do not visit any locations mentioned in the testimony. In this age of electronic communications, you must not conduct any independent research about this case, the issues in this case, or the individuals involved in this case. You cannot use any tools to communicate electronically with anyone about the case, including your family and friends. You shall not communicate with anyone about this case through email, text messaging, on your cell phone, iPhone, or through any blog, or by way of any other social networking websites, including but not limited to Instagram, Snapchat, Twitter, Google, Facebook, LinkedIn, and YouTube. You shall not consult dictionaries or reference materials or use any other electronic tools to obtain information about this case or to help you decide this case. Do not send or accept any messages from anyone about your jury service. You must decide this case based solely on the evidence and law presented here within this courtroom. You cannot allow any other persons to discuss the case with you or in your presence. If anyone attempts to do so, report the conversation to the court immediately without discussing the incident with any of the other jurors. Anyone who receives any other information about this case must notify the court immediately. Until you begin to deliberate, you shall not discuss the case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with the other jurors. It is important that you wait until all the evidence is received, all the arguments have been presented, you've heard all my instructions on the law before you begin your deliberations. Any discussions before you begin to deliberate would be premature and improper. You cannot discuss the case with anyone else until you return a verdict and the case is concluded. I do not know whether there will be any media reports in the newspapers, on television, on radio, or in social or electronic media about this trial. If there are, you're not permitted to read, watch, or listen to those reports. You must base your decision solely on the evidence you hear in the courtroom. At times during a trial, an attorney might object to a question that is asked by another attorney or an answer that a witness gives. This simply means that the attorney is requesting that I make a decision about a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and must not influence your decisions. If I sustain an objection to a question, the witness would not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Likewise, if I tell you not to consider a particular statement that was made, you must put that statement out of your mind, and you shall not refer to that statement in your later deliberations. If you have a question about the testimony of a witness, write it down and present it to a court deputy. Your question shall be anonymous. The deputy will then present the question to me. After discussions with the attorneys, if necessary, I will decide whether to ask the witness all or part of your question. For legal reasons, I might decide not to ask a witness a juror's question or ask only part of the question. Please do not be offended should this happen. The law is complex and contains many technical rules that the lawyers and I must follow. Please do not hold my decisions against any party in this case. During the trial, I might ask a question or two of a witness. If I do, that does not indicate that I have any opinions about the facts in the case or that I have any opinions about the credibility of any other witnesses. Finally, I might have to interrupt the proceedings in order to confer with the attorneys about the rules of law that should apply. In some cases, we might have bench conferences in the courtroom outside of your hearing. In other instances, I might have you retire to the jury room while we discuss matters out of your presence. We will try to avoid as many of these interruptions as possible. We'll attempt to resolve some of these issues in the morning before we get started. I request your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. Ultimately, the conferences save time for all of us. After your deliberations, if you find the defendant guilty of any offense in the indictment, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting any punishment in this case. Ladies and gentlemen of the jury, this will complete my opening preliminary instructions to you. Before we proceed with the reading of the indictment, I told you Monday and I told you on March 4th, and I told you in writing that there will be media coverage. In fact, I think the preliminary instruction says I didn't know, but there will be media coverage in this case, which is why you have been sequestered. There are at least 4 cameras in this courtroom right now. One by Deputy Smith, one over at the edge of the jury box, one by Deputy Phillips, and one in the back of the courtroom. They are not going to put you on camera. They understand they cannot put jurors on camera, so ignore the cameras. Don't focus on them. Don't pay any attention to them. They could be a distraction, but don't worry about those cameras. They're here to cover the trial. They can cover witnesses. They can cover what judges and what lawyers say, but they cannot report, cannot cover, cannot put jurors on TV at any point. So please just ignore the cameras and make sure you stay focused on the trial and on witnesses, and just ignore those cameras. Any questions? Mr. Hagerman and or Mr. Schofield. Mr. Hagerman. Deputy Smith. Class trial jacket. Mr. Hagerman, please, sir. Mr. Hagerman, you may proceed with the reading of the presentment of the indictment, sir.